Hello, everyone. Sufit here. I'm here today with Charles B. Ticker, estate mediator, and we're going to be discussing a very interesting question. I'm just going to open and put this question right to you, Charles. Should you take your sibling to court?
No, but
Okay,
it
well,
happens. But it
so this
happens a
interview,
lot.
this interview is over. Thank you very much. Thank you for your
Thank
time,
you.
Mr. Okay, no, you want to
Uh,
elaborate?
of course, people think court's the answer. You know, the panacea. It's the court's the answer to all their problems. And if I can only get my day in court, and having been in this business for a while, I think I can say with quite a bit of confidence that most siblings or litigants, when they find themselves in these kinds of disputes before court, uh, are less than satisfied with the outcome or with the process.
Why are they less than satisfied?
Well, first of all, they have totally unrealistic expectations of what the court system could do for them. For example, everyone says they want their day in court. And I've written about this in my book. It's not your day in court. It's months and years in court waiting to see if you're going to have a day in court. And then you may have your day in court. You're not happy what happens, or the other side's not happy. Now you have your appeal court. So it just goes on and on and on. And so people realize it's costing them a fortune, both financially and emotionally, and it's not a fun experience.
And who's paying for all that?
Well, a lot of people think that if it's an estate dispute, oh, the estate will pay for it. But that's not how it works. Not at least not in my jurisdiction. You know, the loser pays. So you better be right, or it's going to be very, very expensive.
And you say you better be right, but there often isn't a black and white, right and wrong. I mean, who's to say what a judge is going to say is right?
And that's why cases settle, because of the uncertainty of what a judge may or may not do at court. And I say this at the beginning of every mediation that I do. Today's the day that you have control. Don't leave it to a total stranger who may not agree with your side of the story. And you never know what a judge is going to do. One judge might give you one result, another judge the next day give you a totally different result. It's like rolling the dice.
So what if now, in order to get to, so you're saying the alternative is mediation, yes?
In my view, mediation is the way to go when you have a sibling estate dispute.
And but how do you get your brother or sister who also wants his or her day in court? How do you get that person to agree to meet you in a mediation room?
Well, in some jurisdictions, particularly in Toronto, there's Toronto, Ottawa, in the Windsor area where mediation of these disputes is mandatory. So you don't have a choice. You have to try mediation before you have a court hearing. But what we're finding is that because mediation works so well with these types of disputes, is that lawyers are agreeing to go to mediation, and judges even have the authority in other jurisdictions to order mediation. We're finding cases from all jurisdictions in Ontario going to mediation because it is the best process in my view.
So here's the question. Can you get to mediation without even initiating a legal proceeding in the first place?
Of course, and I see this all the time. And I always commend the parties for taking that approach before blowing their brains out on a lot of legal expense. They agree to sit down and try and resolve their differences with the help of someone like myself, so they can avoid this very lengthy and costly court proceeding. The tough question is, you know, how soon do you go to mediation? And that's sometimes not the easiest question to answer.
Okay, since it's not the easiest question to answer, let's put that question to you right now. What time should you go to mediation?
Well, I've written about this, and you know, every case turns on its own facts, but you need enough information so you can have a meaningful dialogue at the mediation. So what do I mean by that? Well, number one, what are you fighting over? What's the size of the estate, or the size of the pie, as I like to call it? If you don't have that basic information, if you haven't gathered it from the financial institutions or real estate appraisals, whatever, you're not ready. And sometimes you do need to commence a court proceeding so you can get access to other information like medical records of the deceased to see if they had any cognitive issues, the lawyer's drafting file for the lawyer who drafted the will. So sometimes you have to commence a proceeding just to get that information, but you don't always have to. But clearly, in my view, the sooner you mediate, the better, because if the case has gone on too long, people have now spent a fortune on legal fees. They get very entrenched in their positions, and it makes it more difficult to settle the dispute.
All right. Well, our guest today has been Charles B. Ticker, estate mediator, answering really in one word. At the opening, spoiler alert, you don't have to listen to the whole video. The question, should you take your sibling to court? And for those of you who missed it, the answer was
No.
thank you very much.